Okay, first rule of Zoom, make sure your laptop has a full charge. Hi, everybody. My name is Jennifer Wilson. I am the Deputy Director of the League of Women Voters of New York State. Thank you so much for being with us today for this discussion of the 5 ballot proposals all New York State voters will be voting on this fall. I am very excited to be joined by a panel of 3 expert speakers who are going to help me go through the 5 proposals and make sure that all of you are fully prepared to vote on these proposals in the fall. Before we start, I want to give a special thank you to the Newmark Foundation, Newmark Philanthropies, for sponsoring all of our voter education work this year. We could not have done it without their support. And now I want to turn us over to some basics that I hope everyone here knows. And if not, take a screenshot of this page, take a photo of it, and make sure that you know these are the dates that you need to know even before we learn about these proposals. Election day this year, November 2nd. But in New York State, we have early voting now. So if you want to vote early, you can do that between the 23rd and the 31st this year. October 8th is the last day to register to vote for this election. And this date is a new date. October 18th is the new date to submit your request to vote by absentee ballot. So if you want to vote by absentee this year, you have to do it by the 18th. You can do that by mail, online, by fax, by email, but it's got to be in by the 18th. November 1st is the last day if you want to go ahead and apply in person at your county board. November 2nd is the last day to postmark your absentee ballot, and it's also the last day to go ahead and hand deliver that. The ballot proposals will appear on the back side of the ballot, which is something that some of you may be unfamiliar with. So the last thing is to make sure that when you go to vote, or if you're voting at home, or if you're voting early, that you go ahead and flip that ballot over. So now we know all the dates, we're ready to learn. And all of the materials that will be shared in tonight's presentation are also available in a handy brochure format through the League. Our Voter Guide Part 2 has all of these ballot proposals, including an explanation for each and nonpartisan pros and cons for each, available in English, Spanish, Korean, Chinese, Burmese, Karen, and Arabic. So if you are watching this and you want to make sure that you really got this down, you can go on our website and find links to all of these different voter guides. I'm also going to put them in the chat when I'm done talking so you can have them handy. And with all of that out of the way, let me introduce you to our expert panel for this evening and the order in which we're going to be covering these proposals. So the first proposal is going to be covered by me. This is a proposal to amend our redistricting process here in New York State. Our second proposal will be presented by Kate Carrera, Deputy Director of Environmental Advocates. That proposal is about adding the right to clean air and clean water and a healthful environment to our Constitution. Proposals 3 and 4 will be presented by Jared Berg, co-founder and Voting Rights Council of Vote Early NY. Proposal 3 is with regards to eliminating the 10-day advance voter registration requirement. And proposal 4 is regarding authorizing no excuse absentee voting. And finally, proposal 5 is going to be presented by Judge Philip Trinieri, retired supervising judge of the Civil Court of Richmond County. And the 5th proposal is with regards to increasing the jurisdiction of the New York City Civil Court in our state constitution. Now, the last thing before we jump into the proposals is please use the Q&A feature if you have any questions during the presentation. We will respond to them all at the end. We have a lot to cover in a short time frame, and I want to leave plenty of time for questions at the end. We may go over the hour, but I want to at least keep this part to the hour. So with that, let's get to the first proposal. Proposal number 1, amending the apportionment and redistricting process. The question as it will appear on the ballot is as follows. This proposed constitutional amendment would freeze the number of state senators at 63, amend the process for the counting of the state's population, delete certain provisions that violate the United States Constitution, repeal and amend certain requirements for the apportionment of the appointment of the co-executive directors of the Redistricting Commission, and amend the manner of drawing district lines for congressional and state legislative offices. Shall the proposed amendment be approved? Now, this is by far the most complicated of the 5. So we're starting off with the hardest, which hopefully will make you feel better when we're done with this one and you understand it very well. And before I can really take you through what this amendment is going to change, I want to take everyone back to the ultimate basics. And some of you probably know this, but if you don't know this, there's no shame in not knowing this. It's very obscure, government-y type stuff. So to take us back to the most basic, what is redistricting? Redistricting is essentially redrawing our legislative districts according to the population, essentially according to census data. And I hope you all filled out your census, but whether you did or didn't, your districts are going to be redrawn this year. And the legislative districts we're talking about here are the state Senate, the state assembly, and Congress. These are not the only levels of government redistricting happens at. That's just what we're talking about here with this amendment. Redistricting in New York State is led by a commission. That commission is appointed by the legislature. And ultimately, the state legislature, the state assembly, and state senate ultimately will approve the proposed maps after the commission has drafted them. And as I said before, redistricting is happening right now. Like literally today, the commission met and had a meeting to talk about their mapping plan. And you can find out more about that at nyredistricting.org. But this is the basics that you need to sort of understand what the changes in the amendment are in relation to how redistricting is done in New York State. So again, I wanted to make this as simple as possible. So I've broken the changes down into controversial changes and uncontroversial changes. The uncontroversial changes are essentially constitutionalizing a lot of things that are already in state statute here in New York State. We already have 63 senators, that's in state statute. We already reappropriate people who are incarcerated back to their last residence, that's in state statute. The language that's unconstitutional according to the US Constitution refers to aliens. Basically, our Constitution says don't count undocumented people in our count, and we have to count undocumented people in our count, so we have to take that out. It's also going to change the timeline for submitting the planned maps from the commission to the legislature from approval. Currently, the timeline says that the maps have to go to the legislature by January of the year ending in 2. And that's a problem because when this amendment was initially passed in 2014, the petitioning process for candidates to be on the ballot happened later in the year. So essentially, candidates looking for signatures to run for Senate, Assembly, and Congress happened later in the year. Well, now it happens earlier in the year. So early, in fact, that if the first set of maps is rejected by the legislature and the commission has to propose a second set, there is a potential for candidates to be running for offices that don't exist. So the proposal would move up that timeline from January of the year ending in 2 for maps to go to the legislature in November of the year ending in 1. It is important to mention, though, this will not take effect for this year because by the time this amendment, if approved, is approved and signed into the Constitution, it will be January. It will be too late to change the timeline. So those are the uncontroversial things. The controversial things are all related to the voting process of approving the maps for both the commission and the legislature itself. The current rules have a fail-safe mechanism in place if a single party controls both houses. And I'm gonna use a real world example here because this is the real world and this is our reality that we're living in. Right now, Democrats control both our Assembly and our Senate. The current rules require a minimum number of minority appointed commissioners and minority legislators to vote in favor of these maps. This change would take away that fail-safe. So it doesn't matter who's in control, it doesn't matter who's in charge of either house. It could be both the same party, both different parties. The rules will be the same. There's no fail-safe to make sure that the minority party has input into the process. This is also going to change the appointment of the co-executive directors. Right now, it's one from the major party, one from the minor party. This would say it doesn't matter the party. And it would also allow the legislature to propose their own maps should the commission fail to deliver maps by that November date. The current law basically says the commission has to hand over the map that got the most votes for the legislature to work with. This plan would say that the commission would just hand over the maps and the legislature could draw their own maps, essentially. So the pros and cons. I think the controversial, non-controversial kind of shows you what the pros and cons are, but essentially the pros are we'll constitutionalize a lot of things that are already in state statute, which is great. We're going to change the timeline, which we have to do regardless, because at some point it's probably going to be a problem that maps could be rejected and candidates could be running for offices that don't exist. But again, that won't take effect this year. And it simplifies the voting rules, which makes my life a lot easier, because when I'm explaining this to voters, it's a lot easier to say, yeah, the commission votes, it's a majority, the legislature votes, it's a majority, than for me to explain the nuance of all of the rules if there's the same party in control. Now, I think you can figure out the cons here too, which is we would essentially be giving one party, the majority party, unfair rule of the redistricting process should they be in control of both houses. And when I'm saying minority party, I'm not just talking about the Republicans, I'm talking about all of the many types of parties in New York State, whether it's the Green Party, Working Families Party, Libertarian Party, Conservative Party. All of those parties could be considered part of the quote unquote minority party, as well as unaffiliated voters. So it would essentially be one party versus everybody else in the state. And you could argue, well, if the majority of legislators are of that party, certainly that represents the majority of voters. And I can play devil's advocate with myself, and I can see that. We also will have the potential to reduce the role of the commission. This proposal really disincentivizes the commission from working together, since there is an equal number of majority appointees and minority appointees. If the minority party knows that the majority party can overrule them in the legislature when they vote on these maps, it disincentivizes them from working together. And the other thing is that all of these rules, they're not going to take effect for this redistricting, or they are going to take effect for this redistricting cycle, except the one that we need the most, which is changing the timeline. This is our first time ever having an independent commission draft our lines. The initial amendment that created the independent commission was from 2014. So this is our first time even having a commission-led redistricting process. So we've never seen it work. We can't really say we know what the problems are because we've never actually had it do its job. There's no reason to do this right now necessarily. We could wait until future years when we're not redistricting, because the one thing that is timely is changing the timeline, and we can't do that right now. So as you can see, there's a lot of pros and cons here, and I'm going to drop a really great in-depth article into the chat when I'm done talking that explains this a little bit more, and the league will have more information on this particular amendment in the coming weeks, because as I mentioned, it is the most complicated. But I'm not going to take up any more time. I'm going to go ahead and turn us over to Kate Carrera, Deputy Director of Environmental Advocates, to take us through proposal number 2. So Kate, please take it away.
Hi, everyone. Thanks, Laura. My name is Kate Carrera. I'm the Deputy Director of advocacy organization based in Albany, New York, called Environmental Advocates NY. And I'm going to be talking to you today. Laura, I'm not sure if you're going to advance the slide about proposal number 2.
Sorry.
That's okay.
Oh, sorry. My computer is freezing up. Can you see the question slide?
I just see proposal number 1 on my slide, but I can keep going if other folks can see. So this proposal would add a right for each person to have the right to clean air, clean water, and a healthful environment. And this right would be added to the New York State Constitution, Article 1, which is the Bill of Rights section of our state constitution. The question as it would appear, it seems like other folks can't see the slides as well. I might just pause for a second until we fix that technical glitch.
Sorry, guys. I don't know what's wrong with my Zoom. So sorry, my computer is completely freaking out now. So typical.
I could share my screen.
Yeah, see if you can override my my slide deck.
Okay.
So sorry, everyone.
And can you just close out of screen sharing and go back in?
It's not even letting me close out of screen share. Technology never works the when you want it to. Okay,
1 second. Okay, so I think I should be able to share my screen. I'm going to try to do this. Can you see my desktop? Did that work?
Yes, Kate, it worked.
Okay, sorry. Thank you, everyone. So I might start again. So my name is Kate Carrera. I'm the Deputy Director at Environmental Advocates NY, and I'm talking about proposal number 2, which will appear on the New York State ballot in November, which would provide a right to clean air, clean water, and a healthful environment to the New York State Constitution. And actually, this would be an amendment to Article 1, which is the Bill of Rights section of the New York State Constitution. The question, as it will appear on the ballot, is the proposed amendment to Article 1 of the New York State Constitution will establish the right for each person to clean air, clean water, healthful environment. Shall this proposed amendment be approved? Pretty simple, straightforward question. So next I'm going to kind of just talk about, as Jennifer did for the other proposal, just some pro and con arguments on this measure. So as a starting point, I really like to talk about this amendment as having kind of real 3 cornerstone pro arguments. First, it's a really important value statement that every New Yorker in the every New Yorker in the state, regardless of their zip code, the color of their skin, or their economic status, would have this fundamental right to not be impacted by dirty air, hurtful and a hurtful environment. So have access to clean air, clean water, and this healthful environment. It's really elevating this right that doesn't exist. We all think we have this right, but doesn't necessarily exist in a legal standing in the basis of the Constitution, just the way we have fundamental rights protected under the state constitution, like such as our rights to free speech, religion, to get divorced, and even in New York, your right to play bingo is protected under the Bill of Rights section of the Constitution. So that's kind of one starting point of understanding the value and the importance of elevating this right to the Constitution. The second way that it would be used in a pro is it provides another screen on government action. So this is, government is charged now with a greater, to give greater consideration to the environment and to these rights and all of the decision-making processes that happen, which means from the legislature, from passing a law to a local municipality, passing an ordinance to a state agency or authority issuing a permit. So it really allows this front-end decision-making to consider the impacts of the environment before. The third pro argument is that it's another important tool in the legal toolbox to help protect against infringements of these rights. We have seen time and time again, even with all these environmental laws on the books and regulations, we still are confronted with environmental injustices and racism and instances where people's rights to that clean air or clean water are being violated. And so this elevating to the Constitution, providing it in this section of the Constitution does enhance the legal enforcement and standing that one being a community, individual, a business, a government even, to help protect against that infringement. In terms of some of the con arguments that are out there, there's certainly been mentioned that this could open up a floodgate of frivolous lawsuits. There are a number of other states that have a similar right. Lots of states have an articulation of environmental rights, but there are really only 2 that have the same level of a constitutional fundamental right, and that's Montana and Pennsylvania, and they have not seen this so-called floodgate frivolous litigation occur, but that is definitely one of the concerns. One of the other concerns is kind of the flip side of what I said. It's unnecessary and duplicative. We have lots of environmental laws that are on the books, and therefore this isn't necessary. The wording of the proposal, of the right is very general, as you would see. So there is criticism about what does that mean, clean air, clean water, healthful environment, and that somehow that generality would be a burden and provide uncertainty to a regulated community as well as the courts in interpreting. And then lastly, we've also heard that something of this nature could have economic impacts on New Yorkers. So that's all I really had in terms of the pro and con arguments. I'm happy to answer questions. I think that you know, a number of the con arguments we certainly don't necessarily think have a lot of weight, or we haven't really seen. We also know that these economic arguments have often been made, but we also know that when people are healthy and happy and not using up healthcare costs, we have a better economic outcomes. We've seen that very regularly. And in terms of some of the criticism about being too general, we certainly would expect courts to defer to regulatory agencies that have implemented standards and stuff, and that would be important. And really, courts' jobs are to interpret laws. So having vague words is not something new that courts often have to adjust to. So I will stop with that and perhaps unshare my screen, or would you like me to keep going? I don't know.
Do you mind keep going? I'm so sorry. It's a typical anything can go wrong will go wrong. So if you wouldn't mind still doing the screen, because I can't see anything, and let's turn it over to Jared Berg of Vote Early NY.
The only caveat, Jennifer, is that I'm not sure if this is the last version that you had sent around.
Is it from the Google slide deck?
It's from the Google slides.
Okay, then yes, I just did that one. So sorry, guys.
All right, I'm going to move on.
Thanks. So hi, folks. It's a pleasure to be with you. I do want to thank Laura Ladd-Bierman and Sally Robinson and Jennifer Wilson for their leadership and for organizing this program. And before I dive into the third and fourth proposals, as a league member myself, I just want to say how grateful I am to all of you, you folks who are in the counties, members of your local leagues, doing the civic engagement work. That is what makes our democracy stronger. So thank you for being here and all that you do. If you're not a member of the league, check them out. It's my unsolicited plug. So the third proposal would remove the requirement presently in the state constitution that voter registration shall be completed at least 10 days before an election. And this is, it's pretty straightforward, but our current law is a little confusing. So I'm going to try to explain that. So the Constitution currently says that laws shall be made, among other things, for the registration of voters, which registration shall be completed at least 10 days before each election. But that is not the current rule in New York. So here's sort of the background. As of 2021, there are 20 states plus Washington, D.C., that have implemented some form of same-day voter registration, which means that an otherwise qualified resident could register to vote and cast a ballot at the same time. I like to call it one-stop registration and voting. Of those states, 18 and Washington, D.C. actually allow election day registration, as in you could register and vote on election day, not just during early voting. Montana and North Carolina are the two that allow registration during part of early voting, but not on election day. And Montana just regressed this rule in spring of 2021. In New York, as I mentioned, the voter registration deadline is not 10 days before a primary or general election. It's actually set by statute at 25 days prior to an election, more than 3 weeks before an election day. So in 2021, that's October 8th. And in a presidential election year, that deadline falls prior to most of the presidential debates and the many candidate town halls that occur in the run-up to an election. So I mentioned before, I'm a fan of the league. I'm a member of the league. I consider league members and those who would tune into this kind of program to be perhaps the most civically engaged audience there is. But to put that in perspective, it would mean that to join this program tonight, you would have had to RSVP by August 15th at the latest. So to clarify, the 10 days requirement on the ballot that we all will be able to vote on, it's entrenched in the state constitution, but the legislature hasn't enacted anything close to that, even with the power to do so. And it's not clear exactly what sort of policy they would enact if the amendment passes. So we don't want to be too speculative. States do different things here. The amendment we are voting on would merely allow them to enact a system that permitted registration sooner than 10 days before an election if they decided and agreed to do so. So in states that allow same-day registration, and we don't know what they would do if they decided to move that forward beyond the 25 days or even into the 9-day early voting period or election day. In the states that allow this, the voters either vote provisionally or they need to provide proof of identity and residency before they vote. If the voter can't do so, then they cast a provisional ballot, which is counted only after the right to vote's been verified. So to jump into some pro and con, the first pro is greater voter enfranchisement. I think intuitively we understand that when you reduce barriers to access, more people have the ability to participate if they are motivated to do so. It's not a silver bullet, but the opposite's also true. I like to think about this outside the election context. It's why Amazon makes it so easy to complete a transaction online. It's why movie theaters sell tickets at the door. It's why restaurants take walk-ins. So that's one pro. Another pro is increased voter turnout. Actually, when you make the registration deadline closer to election day, even though the relationship between access and turnout is a complicated one, studies do show that states see a boost in turnout. On average, I read about 5% when they move to a system of same-day registration. It invites more people to the democracy party, so to speak, later in the process. It can lead to more accurate registration records because it allows people to update and correct their registration. I think it provides a bunch of resiliency against election tampering and safeguards against clerical suppression or glitches. So if there's some sort of problem with the registration rolls, people can correct those in real time during an election and still cast a ballot that should count once the residency issues get meted out. I think it provides better customer service. It's the sort of thing where if a person shows up, they believe they're eligible, and it turns out that they are, that they can participate and they're not either turned away or they participate and then they're told, well, your vote didn't count because you missed some deadline. So it improves the civic experience for people who want to vote. And on that note, it's more in line with our modern commercial expectations of signing up and participating in something. It mitigates or eliminates the largest source of citizen suppression. I call it suppression by process in New York elections. We foiled for some post-election data. We requested information from the various boards for 2020. And actually the largest source of disqualified provisional ballots in election 2020 in New York came from those who either did not register at all before voting or those who registered but failed to do so by that 25-day deadline. On the con side, by allowing more people to register closer to an election, it does create more difficulty for administrators to determine how many ballots or resources and personnel they might need at a given poll site, at a given early voting site. So the argument goes, by freezing the electorate a few weeks out, officials have a sense of how many people are eligible to vote when they then make those estimates and assessments of how much paper they need, how much personnel they need. Same-day registration, another con argument, it gives officials time to investigate, more time to investigate voter eligibility and residency, and to essentially lock the voter rolls. Moving to a system like this raises the specter of potential fraud or election meddling because it allows people to register closer when it might feel like the stakes in the election are higher or the outcome might be more within reach of some meddling. The next argument is one that we actually hear a lot. It makes it too easy for less civically engaged American citizens to vote. There's sort of this personal responsibility sentiment among some Americans. And I will just say that I do not personally share this, but so the view goes, people should really want to vote and be motivated to do so and to take some action in advance and need to work a little, right? It's an important right. So you should work a little bit to have a say in our government rather than be turned out by campaign operatives and interested partisans. So you know, abiding by deadlines is just part of life. Missing a deadline usually comes with consequences. And so the argument goes, if you're not responsible enough to meet that deadline, therefore, so goes your right to vote. Not my personal view, but those sentiments, we hear those a lot. And there is a very sort of person on the street, common sense ability to that. Although in practice, I think it's more complicated than that. Another con is more work for administrators to competently manage this function while they're conducting the live election. And so, and I think this is actually a matter of local administration. Certainly, whatever the state policy is needs to be well thought out. But if it's not structured correctly, then at a poll site, this could create bottlenecks at the polls and potential delays. So I hope we're doing okay on time. I'm going to move on to Proposal 4. Proposal 4 would eliminate the requirement that a voter provide a reason for voting by absentee ballot, which would allow any voter to request an absentee ballot without an excuse. This one's a little more straightforward. Right now in New York, the only permissible excuses are actually delineated in the state constitution. It's Article 2, Section 2. And you can see it up there, the question on the ballot. So the concept of absentee voting first came about during the Civil War. It was a way for soldiers to cast ballots in their home states. Today, all states are required to send absentee ballots to military and overseas voters for federal elections. So we see that sort of initial strain is still very much a part of our voting culture. But beyond that, 34 states and Washington, D.C. now allow any voter to vote absentee or by mail without providing an excuse. 5 of those states conduct elections entirely by mail, which means voters automatically receive a ballot. They don't need to request one. And in 16 states, which of course includes New York, voters are still required to provide one of a limited set of statutorily permissible excuses for why they can't appear in person to vote. And to give you a sense, in New York, being busy with work or school or parenting, that sort of thing, that doesn't qualify. The pro arguments here, I think everyone on this call is presently living through a pandemic. I think that what we've seen is the ability to vote by mail, to vote absentee in such a situation actually protects your rights. So it increases voter access. I like to say that options protect your rights, especially when unexpected events or obstacles arise. I'll discuss a couple of those in a minute. It reduces the volume of in-person voters, the lines that come with that, and some of the most labor-intensive interactions between poll workers and voters who might need some assistance or a little more time or have questions. This one, the next pro, I don't think gets talked about enough. But when we talk about big picture, like what should our voting system look like, I think opening up the absentee voting process ensures resiliency of our American democracy infrastructure. So whether it's storms or illness like the pandemic or some other sort of grievous illness, or local or systemic election meddling, I just think that if you spread out the turnout pattern across space and time, it makes it less likely that the entire election gets disrupted. You folks can think about Superstorm Sandy or September 11th, both of which occurred during or on the cusp of an election, both of which impacted New York's election. One was a primary, one was a general election. But by spreading out that turnout pattern, it makes it less possible that some sort of specific disruption has an outsized impact on the overall contest. So here's an interesting one for city voters. I think they'll appreciate this one. Moving to a system where more people can vote absentee, anyone who wants to, creates more time for voters to research the candidates and comfortably mark their ballots, which just makes the voting process less stressful potentially. So whether it's ranked choice voting, and now you have the option to vote for many more people, so there might be more research. I like to think about it like a take-home test, or if there's just lots of down ballot races, it's appealing to let people vote from the comfort of home, maybe with their reading glasses, maybe sitting down, maybe without feeling like there's a long line of people breathing down their necks behind them. So if anyone's been in like a stressful, rainy, long line voting environment, we know that when people are busy and stressed, they tend to make more mistakes. They rush, they might not take all the time they'd want. And this is important, right? Voting is important. What's on the ballot is important. Last pro is that it allows elderly, disabled, and infirm folks, and those who are unwilling or just unable to deal with lines or crowds to avoid them entirely. It speaks to some of those most labor-intensive interactions that I mentioned earlier between poll workers and voters. And I think it provides people far more dignity if they're not with the capacity to be around crowds. Some con arguments, potentially it provides less protection against instances of voter impersonation fraud or foul play. I think, so the argument goes, if you don't have to appear in person with your name and face and sign in front of people or present some kind of proof, people might feel like it's easier to pull a fast one or manipulate the system. Potential for loss of anonymity with more absentee voting, especially in places where the vast majority of voters vote remotely, that drastically reduces the pool of people who need or want to vote in person. And so they might have less anonymity. You get a less complete picture of the results on election night to allow for people's ballots to come in. That means slower reporting. We certainly saw that in 2020. But as a result, you wouldn't really have the vast majority of ballots in under our present system. That said, the legislature did make some recent changes to get the bulk of absentee ballots in and counted sooner. So that's sort of dependent on how the system's designed, but we all saw how election 2020 played out between 8 p.m. on election night and the days and weeks after. So you can see a shift in the results, which raises people's public trust concerns about the system. More deadlines, right? There's more ways for a ballot to be lost, damaged, or disqualified along the way. There's the logistics of mailing. And the other con is that there's this shared civic experience of voting with neighbors on a set date or location, and that's lost. We heard that around the enactment of early voting too, but that's another con. To wrap, I will just mention two arguments that I think can cut both ways. Voter intimidation and the secret ballot and dirty tricks. This is one. So on one hand, intimidation or suppression tactics at targeted poll sites, right? That's been like the longstanding top tier voter protection concern for folks who have done election protection or election monitoring. Examples of those that we've seen very recently and not just in the modern era. Aggressive or organized caravans, protests, roadblocks, construction at poll sites, uniformed personnel, election violence, and other misinformation about what might happen to you or a family member were you to turn out and vote. By opening up the process for absentee voting, it just makes that more diffuse. Voting takes place over days and weeks. There's not one central location that can sort of be meddled with to impact the election. On the other hand, without the private voting booth in a very public space, voters may not feel completely free to vote their conscience. And we know that, different cultures, people's households, your right to vote is supposed to be your right to vote exclusively. And the voting box booth, at least in theory, creates a private space where nobody should be able to actually know what you did and weigh on you. The other one I have to mention is language and disability assistance. So from home, and I mentioned earlier, a voter can vote on their own schedule. They could seek language or interpretive or physical assistance from anyone they want. But at the polls, if a voter needs assistance and they're not accompanied by a trusted friend or family member, bipartisan poll workers or interpreters are there to help and answer questions. The last one that I think could cut both ways, spoiled, under, or overvoted ballots. So with more time to mark ballots and less stress, the ability to sit, do your research, not be rushed during voting, people might make less mistakes or take the time to learn about down ballot races and more lesser known candidates than they would if they're sort of in a rush and just trying to get through the process, waiting online, that sort of thing. But if your ballot gets damaged or stained, or you make an error when you're voting an absentee ballot, it's much harder or it takes longer to replace it. I think I'll stop there. I hope I did okay on time. Thanks everyone for tuning in. Please don't forget to vote on these 5 questions.
Thank you, Jared. Yes, you did great. And we have our final speaker talking about the final ballot proposition, Judge Philip Stranieri, retired supervising judge of the Civil Court of Richmond County, was also the acting Supreme Court Justice and member of the Civil Court Committee Council on Judicial Administration. So please, Judge Stranieri, take it away.
Good evening. Well, this proposal will increase the jurisdiction of the New York City Civil Court. The current limit is $25,000, which means that you can't sue for more than $25,000 in civil court. Well, you can, but you can only recover $25,000. You have to forfeit any award claim above that, and it would raise this to $50,000. It'll appear on the ballot that the proposed amendment would increase the New York City Civil Court's jurisdiction by allowing it to hear and decide claims for up to $50,000 instead of the current jurisdictional limit of $25,000. Shall the proposed amendment be approved? Okay, I guess you can flip. I'm going to go through some things that popped into my head about this, and we'll take a run at it from there. Like the chicken soup your mother gave you when you had a cold, or the Vicks vapor rub she placed on your chest, this proposed amendment can't hurt. Unfortunately, it does very little to alter the structural problems with the New York State court system, which makes it dysfunctional and as a result, less responsive to the changing needs of the public. The New York City Civil Court was created in 1962. There are currently 120 judges elected to the court. It appears that an additional 11 judges have been authorized by statute, but the seats were never created. Lest you think this is an anomaly, the New York State Supreme Court is supposed to have 1 judge for every 50,000 residents. Based on the 2020 census, there should be 404 judges statewide. Yet this past June, the legislature created 14 new judgeships, bringing the total of Supreme Court justices to 350, about 30 short of the number justified after the 2010 census. Because of the structural problems with the New York court system, only about 50 civil court judges actually sit in civil court. The rest are assigned to criminal court, family court, or the Supreme Court to serve as acting Supreme Court justices. Serious consideration must be given to the Chief Judge's proposal to amend the Constitution and restructure the entire state court system. About 30 years ago, a similar ballot proposal twice went before the voters to raise the jurisdictional amount of cases in civil court from $20,000 to $50,000. Both initiatives were rejected by the voters, which of course raised the question as to why the monetary jurisdiction of the New York Civil Court, or any other court for that matter, is a constitutional rather than a legislative matter. And why does the entire state get to vote on an issue that only affects New York City? To keep pace with inflation, the current $50,000 proposal, if translated to $1990 when the last proposals were up, should actually seek to raise the jurisdiction to $100,000. Because this is a constitutional process and not legislative, in 10 years, will we be back before the voters to do just that? A reason to raise the amount to $50,000 is that it will enable litigants to bring litigation in civil court rather than Supreme Court and save a substantial amount of money on filing fees, about $45 versus over $300. On the other hand, it will generate more filings in civil court, which at one time was the busiest court in the world. Several 100,000 actions are brought every year. Where will the judges and support staff come from to handle the increase? If adding more cases to civil court calendars is not accompanied by more staffing and thereby delaying resolution of the dispute, how is anyone benefited? The proposed change will do nothing to do with the real problem in civil court, the inability of defendants to retain counsel. Most defendants in civil court are unrepresented, as are many non-corporate plaintiffs. This is because the cost of hiring an attorney to represent an individual in civil court with a $25,000 limit may outweigh the potential recovery or the potential recovery to the plaintiff or the loss to the defendant. Perhaps raising the amount to $50,000 will change that calculation for some litigants, and they will retain counsel. On the other hand, if you can't pay the debt, you probably cannot afford to pay a lawyer, no matter what the jurisdictional limit is. As a practical matter, many cases where the damages being sought exceed $25,000 that are filed in Supreme Court are transferred by the Supreme Court justices to the civil court for trial pursuant to Civil Practice Law and Rules, Section 325D. Currently, the three biggest categories of cases being heard in civil court are housing cases, which will be unaffected by this change because the monetary cap does not apply to landlord-tenant actions, and the current cases are heard by housing court judges who are appointed and not civil court judges who are elected in most cases. The presiding in most cases is not that the judges are not elected. The second group is no-fault insurance claims, which is litigation which probably should be resolved either by arbitration or mediation and not by the courts. This change will increase these filings, and because of the nature of this litigation, is paper-heavy and time-consuming for the clerks and judges, so more resources will be needed in these parts. The third group of cases is consumer credit transactions. This is the area of the law where there's the greatest disparity between the parties. All plaintiffs, which is the creditors, are represented by an attorney, while almost no defendant retains private counsel. Raising the limit will do nothing to address this issue. It will also increase the number of cases in civil court without adding resources. Perhaps all consumer credit should be in civil court, irrespective of the amount being sought, because whether the defendant owes $500 or $50,000, the issues are the same, and the civil court judges have the expertise in resolving these disputes. This is another reason an artificial monetary limit should not be a constitutional matter. It should be legislative. I'll be happy to answer any questions and the pros and cons. It adjusts the claimed amount for inflation, yes, but it does not adjust the claimed amount for the inflation since the first time this was proposed 30 years ago. It reduces the backlogs and delays in New York Supreme Court. That's the issue of that the legislature fails to give the constitutional number of judges that the Supreme Court needs. And I'm not so sure that the delays in Supreme Court are any greater or worse than they are in any other court. So we're going to move the delays to civil court. That's a pro, right? And the con is may place an additional burden on the civil court by increasing the number of cases. That is clearly what will happen. And unless we correct the inherent problems with the system, again, it's not going to materially change anything, but it's going to make a court where people are unrepresented have a greater burden. So that's my speech for today.
Great, thank you, Judge. And Kate, thank you so much for doing the slides. I still cannot see anything except myself and the judge and now Laura. And Laura is going to take the Q&A and go ahead and take us through there. And Laura, if you wouldn't mind starting with any of the questions specifically about Proposal 5, because Judge Chenieri has to get off right at 7:30.
Okay.
I have
Great.
another lecture.
Thanks, Jennifer, and thanks to all the speakers. For those of you who don't know me, I'm Laura Ladd-Bierman. I'm Executive Director of the League of Women Voters. Jennifer was supposed to handle all of this tonight, but I will step in and ask the questions. I only see one question so far for Proposal number 5, Judge, and that one is, who is supporting Proposal number 5? Do you know what organizations are in support of that proposal?
I have no idea.
No idea. Okay.
I mean, originally 30 years ago, the court system supported it because, it was going from 25 to 50 in 1990. Now, I guess the court system still is supporting it, but I'm not sure, why.
Okay.
When the whole system needs to be fixed.
Here's another question for you, Judge. What about the rest of New York State? Is there a monetary limit there?
The district courts in Nassau, Suffolk, and Westchester have a $15,000 limit. I guess there's nothing on the ballot for them. And if I recall, county courts outside New York City may also have a monetary limit of $25,000. 50,000. I'm not sure. I haven't looked at that in a while, but we're considered the lower courts, so.
Okay, great. Those are the only two I see right now for proposal number 5. So I'm going to go back to, actually to you, Jen. There's a question about freezing the number of senators. In the US Senate, capping the number of senators at 100 has given disproportionate power to rural or small states. Citizens of large states have less power as a result. How is it different in state government?
Well, I don't know that it's necessarily different. All that I will say is that the Assembly has their number frozen in our Constitution at 150. So this is basically going to prevent the Senate from messing with the number of senators if they so choose to. And originally our number wasn't 63. I think it was either 58 or 60 or 62, right around there, a little lower. And they actually increased the number before one of the last 2 redistricting cycles so that the Republican Party could get another seat. So it'll keep the legislature from having the power to mess with that number and just freeze it in place, just like the Assembly's is. And Kate, if you can, and you want to take the slides down so we can see everyone, I think I'm watching on my Facebook live stream to see what it's looking like to
On the
everyone.
other hand, I'll throw, if you let me throw something into
Of
the mix.
course.
As population increases, if you don't have the ability to increase the number of representatives, whether it's the Senate, the State Assembly, or Congress, the House of Representatives, then the influence of each individual in a district is lessened because there's more and more people being represented by a person. So, it has been used in the past to try to keep the Republicans in the majority in New York. But the other side of the coin is that maybe you have to have a system that we can increase the number without going through a constitutional process.
Okay, thanks, guys. Kate, I have a couple questions for you. Does the amendment define clean air and water?
No.
Okay.
It does not. The amendment would appear exactly those 15 words that we had put up on the screen. So every New Yorker has the right to clean air, clean water, and a healthful environment. But there is quite general language in the New York State Constitution that is of similar kind of nature. So it's not unusual for a state constitutional amendment, particularly one that sits in the Bill of Rights section, to be of a general nature.
So Kate, there's another question about, is there a definition for healthful environment? I assume you're saying no to that one as well.
Same answer.
Okay.
Yeah.
Okay. And then there's a question, how is amendment proposal 2 unnecessary?
So the con argument of why it's unnecessary would be in generally one that we've heard from, say, the regulated community, where they view that all the environmental laws and regulations that are currently on the books in the New York State statute book provides the universe in which one should be regulated and adhere by. So that's the unnecessary argument. But the kind of counter to that is that way of governing is all reactive, right? So all of the kind of laws we have on the books to regulate the environment and to protect our environment are all about allowing pollution to occur, allowing degradation of the environment to, when it happens, to repair it. So it's all kind of retrospective, if you will, and having an amendment in the Constitution is a front-end decision-making tool, so that you would hope that when something like that is being applied, you're actually not getting to the point where you are polluting in a way that's detrimental, and that you're taking all those considerations into account before you take the action, as opposed to responding to things, which is really how the environmental law works at the moment.
Okay, Kate, have Montana and Pennsylvania seen economic impact of similar rights on the books?
Yep. So I don't think so. I don't know a huge amount. I mean, Pennsylvania's amendment has been there since the 70s. So the state has not, this isn't a new amendment for them. So a lot of those arguments that we've seen haven't come to fruition in Pennsylvania in particular. I'm a little bit less familiar in terms of when Montana's came into effect, but I would say that kind of fear, which we often hear with all sorts of environmental regulation anyways, that if we regulate or do something to protect the environment, we're going to see this economic downturn. And I think we all have now seen that, obviously with COVID too, when people are sick, that's not good for our economy either.
Okay. Jen, back to you for a minute. Where is the complete language of amendment to Article 1? Wait, is that amendment to Article 1? Oh, maybe that's to you, Kate, huh? Is it? I'm a little confused.
Well, Kate, why don't you answer it for the environmental one? I'll answer for the other one too.
Okay.
Sorry, say it again. Where's the complete language to what the amendment would look like?
Yes.
Okay, so it's not on the slide, but it is just those 15 words. So it would be article, it'd be section 19, I believe. I think I have that right. Section 19 of Article 1 of the New York State Constitution. And it would provide just those 15 words that every New Yorker has the right to clean air, clean water, and a healthful environment.
Okay, and Jen, is the all the language for the redistricting amendment is on our website, isn't it? Or where can they find it?
So the full language of the amendment is in statute, and you can find that on the Senate or Assembly website, although you would probably have a little trouble finding it. So I'm happy to, when my computer is not freaking out, to share the link for everyone to that particular amendment, because it is pretty long for a constitutional amendment. But yes, that was written up in statute and is available. It's just a little tricky to find it.
Oh, Kate, here's another one for you. What is the reality now without proposal 2?
Trying to unmute. Well, I mean, I guess, we continue to be confronted with pretty serious environmental catastrophes. I mean, one that hits home very closely in New York is Hoosick Falls, New York, where you would say that the community and industry that was regulated under New York State law was protecting that community, where it really wasn't. They were drinking contaminated water. We have unregulated contaminants. We have we have instances in Newburgh, all over the state, where we're confronted with pretty significant environmental issues. And, it's not working. The system that we have currently not saying that it's not working, but there are gaps in that. And when there are gaps in that, we should have a constitutional right to fall back on. So while this right, I don't see that this right, the same way I don't see this opening up the floodgates, it's not to be used in every instance, right? We still have lots of regulation, a lot of law out there on environment and how the environment is regulated under all sorts of different policies. So this is not supplanting that, it's really complementing that. So in the cases where communities really have no other option, and in those instances where, those rights have been egregiously, infringed upon, there is a mechanism going that route.
Thanks, Kate. Jared, we have a bunch of questions for you. The first one, are there any changes proposed to count absentee ballots before elections in New York State?
Yes. So just to clarify, that's a question about statute as opposed to the 5 questions that are on the ballot this year. There's a Senate Bill S-1027. It was passed by both houses this year. It has yet to be sent to the governor. It is a sweeping overhaul of how we count absentee ballots that attempts to count the bulk of absentee ballots, certainly those that come in prior to election day, and so that will change both the way that we do, the way that we canvass absentee ballots. They'll no longer be waiting several days for all of those. It will also change the rights and the posture of a voter who requests an absentee ballot, but then for whatever reason, whether they receive it or not, decide to vote in person. It's a long bill. I suggest League members take a close look at that. There's a lot of good things in there. There's some things I don't love in there.
This is a very similar question that just has a little different spin on it. What is the legislature proposed for the time frame to count absentee ballots, and will this need to be changed if this proposition is approved? So I guess based on what you just said, if the governor does not sign the bill that was passed by the houses this spring, if this proposition passes, will there need to be legislation to change the counting of absentee ballots?
So I think your framing is correct. I will say that the short answer is no. The counting process would be exactly what we've all sort of witnessed, right? If they made no change, then with all the flaws and the good things, it would play out the way it has for the past 2 elections and this coming election. That said, on the specific issue that's before us tonight, these ballot propositions, if the people approve it, questions 3 and 4, there will need to be implementing legislation. So I'm answering a slightly different question there. They will absolutely have to pass a law in any case to eliminate those excuses. And on the registration, if they were going to change it, it's 25 days right now. They could have changed that a while ago, and they haven't. So this is not the last word on this. It's sort of the first.
Okay. How does no excuse absentee ballot impact the disabled voter?
Well, with great deference to my colleagues in the disability rights community, especially those that work on voting issues, who are certainly closer and better placed to deal with that. I tried to couch that as one of those issues that I think can cut both ways. So I think there's a lot to be said for the stress of being in a very crowded poll site or just scheduling. I mean, how much time does it take people to vote? How much time is a person supposed to figure into their day, right? And whatever hurdles folks who don't have a disability face, we know that those burdens are always greater for people with disabilities. So I think absentee voting, and I tried to mention both the pro and the con, it gives people more time. They can vote in a climate and environment that's more comfortable. You know, when I started doing this work, there was a year we had 6.5-point font on one of the New York City ballots. So whether you have a disability or not, a visual disability or not, that's a very hard thing to read. And so I think there's a lot of comfort in the ability to vote from home or under circumstances that a person's familiar with. The other side of that is not having access to the ballot marking device if people are relying on that, and assistance. So I do think those can cut both ways. Folks should know that New York does have an accessible ballot that can be used with a screen reader. So they are making strides to make sure that this is accessible. But we know that we're always behind the mark when it comes to making sure that voting is accessible for people with disabilities.
Okay, I think we've touched on this, but just to make sure, is there any likelihood that the legislature would eliminate the statutory requirement if the 10-day amendment passes? Jared?
So if I understand the question correctly, if they pass the amendment, then these rules they're the product of statute, right? It's no longer entrenched in the state constitution. There's been proposals to move it from 25 days to 14 days to 10 days for years, probably for a decade, and those have not passed through both houses. But I do think what we've seen over the last few decades is states moving in the direction of opening up the voting process. We know that when you cut off voting, access to voting, the registration, so many weeks out, you exclude large segments of the population that break later, tune in later, move more frequently, younger voters, new voters, busy voters. So I think the legislature is looking at that. There is implementing legislation, live bills that would move to a system of same-day registration, but none of them have been passed yet. So we don't exactly know what policy they would move to.
Okay. Kate, here's another one for you. Under Proposal 2, would that open the door for natural things like a river, for example, have protections under the New York State Constitution? Other places have started to grant those kinds of rights.
Yeah, so I think what the question refers to is what we've seen in other places, although I don't know many examples in the US, but I do some know internationally where we actually give a right to the environment itself, like the right to the river or right to the natural environment. So this is different. It's not giving a right to, this is giving rights to the New Yorkers. This is kind of an inalienable right that we would hold as New Yorkers, but in doing so, protecting the natural environment, the health and a healthful environment is obviously key to that. But no, one wouldn't be able to like bring an action on behalf of a river's case.
Okay. This one, you can decide if you want to answer it, Kate. If Pennsylvania has the environmental rights language in its constitution and some of its communities have been environmentally devastated by hydrofracking, doesn't that show that this environmental language is pretty useless?
Yeah, it's a good question. So while Pennsylvania still does have some hydrofracking, this actually, a lot of Pennsylvania's use of this amendment that has been in their constitution for a long time, there was a lot of case law before more recent times that really did show that amendment didn't have a lot of force and was a little bit useless. It was resurrected in a case that happened, I think, 2012, where they successfully used that amendment to overturn a state law that was a complete overreach of government in terms of giving away rights to do fracking and to the gas industry. So it was really used in a successful case. And that's really where a lot of the momentum for this kind of environmental rights amendment started in part. And there is a movement across the United States to put these environmental rights into all state constitutions. And I believe even recently, within the last couple of years, the governor of Pennsylvania used that amendment as a basis to veto a piece of legislation in relation to plastic bags. So I'm not an expert in all of the ways in which it's been used in Pennsylvania, but it certainly has been used to strike down overreaches of state government that have been pro-fracking, as well as some other examples. So I wouldn't certainly not say it's been useless.
Thanks, Kate. Before I go to the next question, I just want to let you all know, in the chat box, I did put in a bunch of links for more information on each of the propositions. And there's always the league website, of course, to find out more information on these. But someone is asking, and Jen, I don't know if you can answer this, how do we find out what groups have initiated these propositions? So how can they find out which ones are, in favor or in opposition of any of these proposals? Can you answer that, Jen?
Yeah, so in some cases, there are campaign committees set up for the specific ballot proposals. The environmental one is a great example. A lot of groups support that one, and there's a few business groups that oppose it. But it is a little bit difficult to find specific information about groups who support or oppose these. Technically, the Senate and Assembly get memos on these when they're pending before the legislature, and technically they're supposed to put that on the bill's websites, at least on the Senate side. They said they were going to, but then never did. But if you stay tuned between now and the election, more groups will probably become a lot more vocal about their positions on these. And it's also important to remember that groups taking positions on these oftentimes need to be a C4 group that has the power to take political action, and a lot of groups aren't. So even though they might have supported the bill, they might not be super vocal about actually coming out with their support for it. So stay tuned, I guess, is my takeaway on that.
And
Jen, Jared, here's one that the league would answer, but I'm going to give it to you.
Oh, I think Jared wanted to say more on that too.
Oh, I'm sorry. Go ahead, Jared.
Oh, I was just going to add, I interpreted that question slightly differently. These are all legislative bills. So in New York, we don't have citizen-initiated questions of this nature. So, these weren't sponsored by a particular interest group. They were introduced by members of the legislature and voted on two successive legislatures to put it on the ballot for the people.
Okay. All right. So then, Jared, there's a question. If I'm registered to vote in the last election, will I need to re-register? Is there any language that says when you need to re-register to vote?
So in New York, we have permanent registration. So no, if you've registered to vote and you haven't moved, you will not need to register again. We now have portability. So if you've moved counties, you should re-register. But once you're a New York voter, we no longer kick you off the rolls entirely if you move counties. But I think our law, automatic registration isn't in place yet. And the rolls are still, it's still a manual process. So you have until till the 8th to correct your registration. So the best practice is right now, check your registration. You can fix everything now, right? Time is your friend until those deadlines approach.
There's a question. Does the New York State Board of Elections require groups to state their position on the ballot issues? I can answer that because the league did create a ballot committee, and you did on the registration form have to indicate if you were in support of or in opposition to each of the ballot issues that you were going to spend money or raise money on. So yes, the State Board of Elections does require the groups, if you create a committee, to state your position. Jared, do you want to say anything more about that?
I don't have anything to add.
Okay. All right. Here's a generic one that if anyone who would like to can answer. Will there be commercials statewide to make New Yorkers regularly aware and looking for information?
So
Anybody have any comments?
I can answer this from the perspective of what state law requires, and state law requires that the Board of Elections do a minimum amount of publicity on all of these ballot propositions. And the minimum amount of publicity is essentially that they have to run an ad in a local paper in every one of New York State's counties talking about the 5 ballot proposals, like just educationally. And I think that's all they have to do. So will there be commercials? I'm not optimistic that there will be.
Okay, I don't see any more questions. I don't know if any of the speakers want to make any final comments or things that you didn't get to say during the talk. I guess, Kate, want to start with you?
I think the one answered before, and Jennifer mentioned there are some campaigns that have come together. So just the one that is, I think it's been posted a couple times in the chat, but it is the pro campaign for voting yes for the environmental rights provision is www.ourairwaterny.org. So folks can, there's information on that site.
Great. Jared?
So not much to add. Look, I am concerned that in a year like 2021, people might not feel like there's very much to vote on. We know that there are elections every year, and these questions are incredibly important. They touch on all kinds of issues that will affect our lives. So please help. We need your help to get the word out that these are there. Encourage people to turn over their ballots and vote these questions.
Great. Jen, do you want to bring it to a conclusion here?
Yeah, thank you so much, everybody who joined us, whether you're on the Zoom or watching us via live stream. And this is the first part of the conversation on these 5 ballot proposals. So your questions about publicity and all of that are excellent. And I'm hoping that between now and October early voting, we'll have a lot more information for you all. Laura, can you put my email in the chat really quick for anybody who wants to email me? I will orally say it too. It's just my first name, Jennifer, @lwvny.org. Any questions or concerns, feel free to email me. And thank you all so much for sticking with us this evening.
Thank you.
Jared and Kate, if you want to put yours in quickly too before people leave, just in case.
Thanks for having us.
Great. Thank you guys so much. Have a great night.
Thank you so much.
Thank you.